So, a judgment that could send Rivers State into a political and financial tailspin, with the far-reaching possibility of effectively crippling governance in the state. Just 3 weeks after the Court of Appeal in Abuja nullified its 2024 budget, which was being implemented by Governor Sim Fubara, the Federal High Court, also in Abuja, has now ruled that Governor Fubara's action in implementing what it called an unlawful budget was a gross violation of the Nigerian Constitution. Justice Joyce Abdul Malik called it a constitutional aberration that must not be allowed to continue. So she ordered the Nigerian Central Bank to stop releasing monthly federal allocations to the Rivers State government. She also instructed Nigeria's Accountant General, as well as Zenith and Access banks, not to allow the governor withdraw money from the Consolidated Revenue and Federation account. So another cork in the bottle that helped to keep the political chaos in Rivers State in check has gone whizzing over the garden wall of Government House in Port Harcourt, even as this week a militant group calling itself the Niger Delta Development Force threatened to attack Nigeria's oil installations if such a ruling is made. And now it has. So could it galvanize something more perilous for Rivers State and for Nigeria?
Today's judgment, which has been appealed, is an attack on our constitutional governance and an attempt to undermine the principles of federation. Now, how did a judge arrive at delivering judgment, knowing fully well that the subject matters upon which he wants to base his judgment on are all subjects of appeals pending at the appeal court and the Supreme Court, on the issue of the legitimacy of those pro-Wike sacked lawmakers who decamped at a time there was no division in their party PDP into APC, and their seat automatically by virtue of the constitution became vacant. All of a sudden, the judge was fully aware that the matter is still in Supreme Appeal Court and still in Supreme Court, and his attention was drawn to them. But he rushed to deliver a judgment to seize the sovereign allocation of the people of Rivers State based on a matter that is still being challenged. And not only that, there was petitions and manifest evidence that was brought before her of bias. But she still continued.
And that's the lawmaker there, Ikenga Ogwuche, commenting on what has happened in the Federal High Court in Abuja here today. Well, for his take on today's developments around Rivers State, I'm joined on the line from Port Harcourt by the lawyer and human rights activist, Chief Festus Ogwuche. Chief Ogwuche, thank you very much indeed for joining us. I'm sure you're across today's ruling, the court saying the Rivers State budget was not properly presented, and it says it must be properly presented before further allocations can be disbursed to the state. In effect, it's stopped any further allocations to Rivers State. What's your reaction to the court ruling today?
Well, my initial reaction, that judgment is one of shock. I say this because there's already precedent on the matter. In your intro, you did a very fantastic job of stating it, and we didn't expect anything much different from what is already on ground. In law, there's what we call precedent, and the precedent is anchored on the rule of stare decisis. We have a hierarchy of courts, and once these pronouncements are made from the topmost court, every other court down the line must affirm it, they must obey it, they must respect it. And that is what creates certainty in judicial decisions, and that is what builds jurisprudence and case law for which reference can be made to. I think there could have been better ways of handling the situation, particularly reflect on the fact that a lot of these matters have gone on appeal. The judgments of the Court of Appeal, which you mentioned earlier, is in the Supreme Court and yet to be decided on whether it is appropriate or otherwise to represent the budget to any of the factions of the House that have defected and the one that's in there. And it is for the Supreme Court to decide. And aside that, the judgment of today's case, the Federal High Court is anchored on the judgment of the decision of the Honorable Justice Omotola of, if I'm not mistaken, of the Federal High Court, in which it is clearly stated that the presentation of the budget was done to the wrong members of the House. Be that as it may, we all know the circumstances surrounding that particular decision, which went to the Court of Appeal, and the issues about it, reflecting again on the fact that the defendants, which includes the government of Rivers State, the governor, the clerk of the House, and the rest of them, they withdrew their defenses. Their defenses included the counter affidavit to the originating summons originally filed, the notice of preliminary objection challenging the jurisdiction of the Federal High Court on the matter, the counter affidavit asking the court for a stoppage. And we expected that whatever issue is before the Honorable Justice Joyce Abdul Malik, it should have been abated a little bit to await the decision of the Supreme Court on the matter. But now that the decision had been delivered, and when we look at the law books and begin to understand that the power of the federal government and its institutions and agencies to stop the allocation of resources to a subnational entity or component unit of the federal government is doubtful. I don't think the Federal High Court has that power. One is not here lampooning the decision of that court, but we are looking at it on the basis of precedents, on the nature of the federal system that you operate, anchored again on the concept of federalism, that the subnational units cannot be denied the conglomeracy, if you permit my word, of what that federalism connotes. The sense that it is a federal system that exists at the instance of the states and not the other way around. The states do not exist at the instance of the federal system, no matter how warped our own system is. The likes of Professor Isawa Elaigu has described it as a unitary federalism. I don't know where that exists. But then the issue is the jurisdiction of the courts, which also I can say that the court has jurisdiction because the CBN is a party, the other federal institutions are party, but that alone does not confer jurisdiction. We are looking also at the subject matter. It has to do with the allocation of resources to state entities. And if that be the case, then those other entities that are joined are just merely sort of cosmetic, so to speak, because I think it's something that the State High Court should have taken jurisdiction. Right. The members that went to the Federal High Court in Abuja.
Okay. Go on, finish your thought, but we've got to move on. Your thought.
All right. Should have even brought it before the State High Court here to state that for so reasons, for that reasons, please do not allow the state government to expend any further resources from the allocation rather than taking it to the Federal High Court. Okay.
Well, I mean, you've made some quite illuminating points there. One of them, of course, being the sacredness, if you like, of precedent in legal sort of proceedings. And we made reference to that 2004 yes. Supreme Court judgment, which declared illegal the federal government's attempt to withhold local government allocations to Lagos State, declaring that attempt unconstitutional. How much does that apply as precedent in this case, or are the circumstances perhaps a bit different?
Yes, that's quite some beautiful question. There's no distinguishing feature between the judgment in the 2004 Supreme Court decision in Attorney General Lagos State and Attorney General Federation. Recall that it was Yemi Osibanjo who was the Honorable Attorney General of Lagos State that time. And if you look at the list of lawyers that made their imputes, I think there were some lawyers that were invited to present their opinions to court by way of friends of the courts, and they did their job very, very well. And the judgment was quite thorough. It was Honorable Justice Uwais Kutigi, the respectable Dicky Toby. They were all on the panel. And if you read that judgment, it's something that applies not just to Lagos State, it's something that applies to every component unit of the Federation. regarding the power of the federal government, its agencies, its institutions, whether administrative, legislative, or judicial, from withholding funds that accrue to state entities that form the component structure of the country. It is totally unconstitutional. And we thought very much that the Honorable Justice Joyce Abdul Malik would advert her mind to it and take consideration of that particular decision. Because the reason for that is not far-fetched. And that is why you see that in most federal systems, the US, Australia, China, you seldom find these kind of decisions from the courts. And the reason is because it is connoted that in federal systems, it is the states that come together to form a unified fora, and they donate their powers to the center. No matter how flawed our own system is, it is the authority of the states that whatever authority it wields, whatever power it wields. So if you deny a state structure of its entitlement by way of its allocation, which should be a replication of what it also contributes, presupposedly contributes to the national structure. If you make such denial, they can opt out of the federation. Right. Which is a possibility. I think one of the states tried it one time in the 17th century and it didn't work. So I think it is preposterous for Washington, for instance, to go and tamper with the allocations that go to Texas from the federal pool. Okay. It is never done anywhere.
Well, I understand that. But so in the context of Nigeria, which is where we are, what are the options open to Governor Fubara now following this development? I mean, it seems like he either needs to find a political way to resolve the crisis or press ahead with further court battles. Which do you expect will be the more difficult option? Which would you advise if you were his lawyer?
I'll first of all start with the option that's available to the federal government. And the option is between the judgment of the Federal High Court today on Rivers State and the judgment of the Supreme Court in 2004, which I think we must derive precedence from. Stare decisis demands that. That is what creates certainty in jurisprudence. That creates certainty in the law. That is what engineers the nobility of the legal profession and the judicature. That in that choice, the federal government should swing on the side of the judgments of the Supreme Court in Attorney General Lagos State and Attorney General Federation. You know, the controversy is beginning to take very the kind of dimensions that one would think is very discomforting for any emerging democracy like ours. We have not fully emerged. A lot of things are still being kept at bay. A lot of issues are still yet to be perfected. The electoral system, the judicial system, the administrative structure, the political structure. And it's something that people should tread very cautiously on matters of this nature. I don't think there's any reason whatsoever for the federal government to deny the Rivers State's authorities of those allocations on the basis of the judgment of the Supreme Court, on the basis of the practice of democracy, on the basis of the federal system that we profess to be adhering to as it is currently, no matter how warped that system is. For Governor Fubara, I think I'll see this move as just an arm-twisting tactic, and I think it will have helped to develop our jurisprudence, because at the end of the day, all these cases will end up by the Supreme Court, and we have a much more enlightened table to make our choices. But then the deprivation is something that it may not be able to swing along, with total indifference to the implications. The orders and the arm twisting techniques is something that he may not be able to overlook, and maybe a political solution may be possible. All these are geared towards maybe getting him to accept certain issues, certain things that may be not acceptable to him. But politics is all about give and take. There are no permanent friends, no permanent enemies. Okay. But then I think these things, we have to strengthen them very, very much, very clearly, to ensure that the judicial system is kept as stable as possible,
right,
and
now,
its nobility is intact at all times.
Now, we heard a supposedly militant group called the Niger Delta Development Force specifically warning that if a judgment like this is made, a judgment they attribute to manipulation and backhand dealing by Nyesom Wike and his deputies, that's their assertion, not ours, that this would unleash, that they would unleash attacks in River State that will disrupt the flow of oil. In that regard, are you expecting some kind of militant escalation to this crisis as a result of today's ruling? What's the mood like where you are in Port Harcourt?
Well, the mood here is that of cautious speculation as to what will happen. Nobody prays for the resurgence of militants in this region. We all were here when this thing was at its height, and it was not a very good tale to tell. And I expected that the forces, the gladiators, the powers that be should put these into consideration and not to overheat the polity unnecessarily. I would say that governance must be allowed to move, and it should not be stopped midway at the instance of a few individuals. We are talking about millions of people that populate River State, both the indigenes and the non-indigenes and the residents, and people who will be affected in so many ways by the judgment given today. That's why it's very, very important that in doing some of these acrobatics with politics and the democratic system which we operate, caution should be put together. I'm not very comfortable with that call by the militants, and nobody wants to look out for any militancy anymore. It was Professor Yemi Osibanjo who came with his dexterity and stopped the wave of militants that was going on here. Nobody was comfortable here at all. We were all running out of the place, and peace and quiet returned. But these political gladiators are very fond of this, and each time it happens, of course, it will result to some calamities that you never envisage. We don't look forward to that. To those militants that are doing that, I think they have to sheath their swords. These politicians, they understand themselves. They can jolly at their own will. They can raise their swords against themselves at their own will. When they settle, a lot of us are not there. And it requires also that the people who are running the affairs of this country should be very cautious about things like these issues of this nature. People are yet trying to grapple with existence, with life, with the excruciating poverty that is ravaging the entire country. And this type of development is totally and completely uncalled for. Charles.
Right, indeed. Barrister Ogwuche, it's a year, I understand today, since the threat of impeachment against Governor Fubara began, and I suppose his fear must be, in terms of reaching some kind of political settlements, that allowing those assembly members back would restart the process of impeachment against him. I mean, do you think that if the threat of impeachment is removed, that the governor would be happy for those 27 members to return, or is that an absolutely no-go area? I mean, in terms of, advancing the potential for a political settlement to this crisis, because it just seems intractable and it's getting worse.
I think it's all a matter of ego. Ego is all about it. Who gets what? Who gets into what political position? Who gets what authority? And it's all, as far as I'm concerned, very frivolous. This issue should not govern the affairs of this country or any component part of this country at all at this very critical stage. The governor had shown by the cases that have been flowing from the courts some bit of predilection to allowing settlements to come in. That was why he quickly allowed the processes before the Honorable Justice Omotosho to be withdrawn, whereas he was the defendant and the claimant, the plaintiff, the person who instituted the action in the first place, has his action intact. So it's sort of a misnomer to conceive that the defendant, who is supposed to be defending, is the first person to withdraw the processes when the president gave an indication that he will intervene to have this matter settled amicably. So that is there, but the fear of impeachment is what actually galvanized all these issues. To the very best of my knowledge, the issue of the return of the members of the House of Assembly, those that have defected, is a constitutional question. You don't apply political issues to resolving constitutional issues. There are two different things altogether. It's a different kettle of fish. And I don't think the Constitution will sanction that kind of procedure, because it touches also on the sanctity of the constitutional document, on the integrity to be accorded that document, because it is well satisfied that those people have moved. And there are documents in court, there's an affidavit showing that they have moved.
Right. We're almost out of time. I don't mean to interrupt you there, Barrister Ogwuche. We're almost out of time. You're making some very interesting points there. But just before we go, and briefly, where do you see peace coming from to Rivers State? Because, I mean, with each blow from one side or the other, we brace ourselves for an equally powerful punch from the other side, and it inevitably ends up weakening all sides, including the innocents who have nothing to do with this raging conflict. I mean, where do you see peace coming from to Rivers State, as briefly as you can?
Yes, the cycle of insuperabilities that we're experiencing in Rivers State is one that ought to be resolved since a very long time if we have institutions that are strong. I know very well there is an action before the Honorable Justice Obile seeking to compel INEC to conduct elections to fill up those vacant seats of the members of the House of Assembly. And be that as it may, I think it's something that INEC should have acted with speed to get those elections conducted. And the members that defected are still very popular. They can test their popularity with the constituency. But I think that the proper thing to be done is to allow the institutions to be strong. The judicial institution, the law enforcement institution, the CBN, you know, particularly the judicial institution, so that the justice system will be accorded with some shade of nobility, with some shade of certainty, with some shade of integrity, so that they give the law as it is and as it's supposed to be, away from travesties, incongruities, and indiscretions. Charles.
Well, thank you very much indeed for your analysis, your assessment, and also for keeping that final answer fairly pithy. Thank you very much indeed. And we were talking there, of course, to Barrister Chief Festus Ogwuche, who is a lawyer and a human rights activist, who was talking to me on the line from Port Harcourt.